This is the American Law Journal.
Big corporations behaving badly. Some call it an American hustle. U.S. prosecutors have enough tools to combat the problem, but if that's the case, then why aren't more CEOs going to jail? Good evening, I'm Christopher Naughton. Welcome to the American Law Journal. There's a lot to be thankful for President Abraham Lincoln. He ended slavery, he preserved the Union, but what you may not know is that he instituted a little-known law that today combats corporate greed. Is it enough? Gina Passarella with the Legal Intelligencer has this.
The Department of Justice has reached an agreement with Bank of America totaling over $16.6 billion.
An historic $3 billion resolution with the pharmaceutical manufacturer GlaxoSmithKline.
In a combination civil and criminal settlement, Pfizer has agreed to pay $2.3 billion.
Some of today's largest corporations are being hit with historic fines and settlements, based on an idea by our 16th president. It's the middle of the Civil War. Contractors are swindling the U.S. Army, charging outrageous prices for shoddy goods and defective munitions. Lincoln's notion was simple: incentivize integrity. Pay whistleblowers to come forward and report fraud and waste. 150 years later, the False Claims Act, also known as the Lincoln Law, is alive and well. And it's created a unique alliance in the law. Private civil trial lawyers representing whistleblowers try to get U.S. attorneys to take their case.
Yes, the government in many of the instances, not all instances, but in many instances, prosecutes the claim. But the role of the trial lawyer is essential in marshaling the facts and in bringing the case to the government.
If that happens, corporate defense counsel know they have their work cut out for them.
That means the resource and the prestige of the government is behind the investigation and the settlement negotiations. I mean, all things being equal, you want to persuade both the government and the whistleblower to drop the case, but second best, persuade the government not to intervene.
False claims settlements over the past 5 years are staggering. But to some, the fact that there's not more than big dollar fines to show is disturbing.
I am concerned that the size of some of these institutions becomes so large that it does become difficult for us to prosecute them.
I'm concerned that we have a mentality of too big to jail.
Whistleblower cases are on the rise, and the stakes only getting higher. More and more government entities have programs in place encouraging whistleblowers to file claims. The key question, will the U.S. Attorney's Office get involved? Plaintiffs' lawyers sure hope they do, but for the defense, the game is all about getting the government to back off of trying their case. Sometimes who gets the better deal might depend on which lawyer has the ear of the U.S. Attorney's Office. For the American Law Journal, I'm Gina Passarella.
Three guests join me tonight. Let's go ahead and meet them. Joe Poluka is a corporate defense counsel with a top 200 law firm, Blank Rome. He's also a former assistant U.S. attorney in the city of Philadelphia. Joe Trautwein is also a former assistant U.S. attorney from the Eastern District of PA. He has worked more on the plaintiff's side of the matter as opposed to Joe Poluka. He is with the law firm that bears his name in Blue Bell, Pennsylvania. Patrick Burns joins us from CNN, Washington, D.C. He is the co-executive director with Taxpayers Against Fraud. And Stephen Scheller has been representing the rights of consumers injured by dangerous medicine and products since 1977. Over the last 5 years, he's recovered over $6 billion in false claim recoveries for the government. His upcoming book is A Nation Betrayed: How Corporate Greed is Killing Our Democracy. Well, gentlemen, take a look at some of the numbers I'm flashing up here on the screen tonight. Here are some of the historic whistleblower false claims settlements over the last 5 years or so. And when corporations break the law and someone blows the whistle on one of the bad acts, they can get caught, they have to pay up. And you see some very large numbers earlier this year, $17 billion, Bank of America. Most of the others are pharma related. Don't these numbers in and of themselves, Joe Poluka, scream criminal behavior?
Not necessarily, Chris. I mean, for one...
Good answer.
Not necessarily. It depends.
Right.
Probably the main reason I give that answer is because for a criminal prosecution, as you know, the burden of proof is much higher than in a civil case. It's beyond a reasonable doubt. The cases are much harder to prove, and frankly, I think a lot of the cases DOJ is bringing now really are cases about the big paychecks that you just talked about, and not about sending people to jail.
Yeah, but this is not just a pecuniary crime. These are not just crimes of economics, Steve. People's lives, Bank of America, people lost their homes, bad lending, bad debt. Glaxo, Johnson & Johnson, people lost their lives. We're not just talking about money here. Maybe we are.
No, we're not, and that's unfortunate. I think I disagree a little bit with Joe, in fact, a lot. I think one of the problems we have is because of the criminal burden of proof and the substantial sums of money that the corporate defendants are willing to pay the government to get out of the net that they've been caught in, the government is basically accepting these settlements. And most of them are more recent in the last few years. My own judgment is that what we really need is some of these corporate top executives need to go to jail, and not for short sentences, because this conduct continues.
Well, Patrick, we hear a lot about the Supreme Court talking about corporate personhood, how money is speech, and how corporations are people, but I don't see a lot of corporations going to jail. I don't see the CEOs going to jail for this kind of behavior.
That's exactly right. In fact, what we're really looking for is to move beyond mere accounting and money and strike right to accountability. And for that to happen, we have to recover America's stolen billions. But we really do have to send a personal message to the liars, the cheats, the thieves who operationalize these frauds in corporations. You nailed it. These frauds are actually about people. And there's a lot of misery. There's poisoning for profit. There's bankruptcy. And it really is about a human tragedy.
Joe Trautwein, again, no one seems to go to jail. And not only that, but in some of these cases where U.S. prosecutors get over $1 billion, we find that the corporations plead to a criminal charge, but it's always a misdemeanor. People's lives have been changed, thousands of lives may be ruined, and all they plead to is a misdemeanor. Why?
Sure, Chris, there are a couple of reasons for that. One of the things you got to look at is that most of the conduct that we're talking about happened years ago, right? By the time these investigations get completed, a lot of the statute of limitations for criminal behavior has elapsed. In addition, you're talking about corporations that may also provide government services that the government relies upon, that wasn't involved in the fraud. And if you charge these companies with felonies, they're automatically excluded. And by excluding them, there may be some good services that they're providing to the government and to the public
so
that would no longer be available.
Joe, are they too big to fail?
In some instances, there are, right? You have some drugs that are being on the market that are being promoted illegally, but there are other drugs out there that have substantial goods for people to take, and those goods will no longer be available.
Patrick, describe these kinds of cases. It's usually a whistleblower and a plaintiff's attorney, a civil attorney, working with the Department of Justice. You've got this triune getting money back for the government. How does it work?
It works very well. The first thing is that you need to have a whistleblower, somebody who understands the fraud, somebody inside the company who has the secret information and the specialized knowledge. That person then goes to a private plaintiff's lawyer, and they package up a case for the U.S. Department of Justice. At that point, it goes to DOJ, who then goes to the defrauded agency and says, is this fraud? Are you interested in us moving on it? If the answer is yes, then you have all three legs moving. But even if the government doesn't join a case, if it's just the whistleblower and his or her lawyer, it's like a two-part epoxy. It can still stick, and it often does.
And it's got to be gratifying for your organization whether people go to jail or not.
It is gratifying to see the money returned to America's taxpayers. But at the end of the day, we're most interested in ending fraud. The way it is right now is if the fraud is not caught, it's paid by taxpayers. And if the fraud is caught, it's paid by stockholders. But inside the companies, the people continue to personally profit. Nobody has to sell their beach house. Nobody goes to jail. Nobody loses their job. And that's what's ridiculous.
Part of the criticism that we've heard about these kind of cases is that whistleblowers get a cut. They get a part of the remuneration that the government receives. Forbes magazine went on record as saying the amounts and rates of remuneration for whistleblowers is obscene.
Well, I don't think Forbes said that. I think somebody who's writing for Forbes. It's important to remember that Steve and Malcolm Forbes own jets, yachts, and castles. So when we're really looking at things that are obscene in the area of money, we really have to look at corporate payouts. We're looking at companies like Omnicare, whose last CEO was essentially pumping drugs into senior citizens, our oldest, our sickest, our poorest. He was eventually fired from the corporation, but walked away with $50 million. Why is it that liars, cheats, and frauds are able to score massive payouts and nobody says anything? But if a whistleblower and his or her lawyer is paid for bringing huge frauds to the American public and the U.S. Department of Justice, that's somehow wrong. It's simply not.
Patrick Burns with Taxpayers Against Fraud from CNN in Washington. Patrick, thanks so much for joining us tonight. Hopefully we'll see you again in the future.
Thank you.
All right, have a good night now. Question, Joe Poluka. I know you're going to have a lot of comments here, too.
Lots of,
All right.
I just heard.
Let me first start here, and I want to go to you and then Joe Trautwein. If we see these very, very high penalties, fines in the billions of dollars, and we're finding that CEOs are not going to jail and corporations are not getting charged with felonies, are U.S. prosecutors not doing their job?
Well, you'd have to ask somebody at DOJ. But let's talk history for a little bit. Chris, when I was an assistant United States attorney in the 90s, it was drummed into my head that corporations do not commit crimes, people do. And somebody like me would come to me and ask, how about a corporate plea? No, we don't do that here. There's been a sea change in the last decade where we've seen these huge monetary settlements and no corresponding criminal prosecutions. But notwithstanding that, it's just much more complicated than the platitudes we hear from Steve and Patrick. These cases are incredibly complex. It is very difficult to build a criminal case against the CEO. Incredibly difficult to work your way to that level. And the other thing,
but it sounds like you can never make a case against the CEO. It seems like the corporation gets a pass. They're too big to fail. They're going to plead to a misdemeanor, and the CEO walks, and everyone beneath him seems to walk as well. We saw it happen with Wall Street. We've seen it happen with big pharma companies. Is anyone going to go to jail for Bank of America?
Like.
And the reason I bring that to your doorstep, because you are one of the former assistant U.S. attorneys on the set tonight, and I've got to be thinking, maybe they're cowed today. Maybe political influence affects DOJ as well. Let me go to you, Joe Trautwein, because I don't want to just beat up on Joe Poluka here. I've got to tell you, I don't know if prosecutors are doing their job. Maybe they can't do their job.
Some of the things that you have to recognize, obviously the amount of time that these cases take to develop, statute of limitations come into play. Again, you mentioned these companies are too big to fail. Some of them provide products that the public depends upon. If you're going to charge them criminally, those products are no longer going to be available to the public, and that would be a bad thing. But I think the sea is changing. As part of these big settlements, we are mentioning the dollars, but these corporations are signing corporate integrity agreements. And these corporate integrity agreements require to some of these top executives that they certify that there are these compliance systems in place to make sure that this fraud doesn't happen again. And they're certifying that this is happening. If it's not happening, and they should have been aware of it, that could expose them to criminal liability.
Go ahead, Joe.
Chris, you mentioned felonies. People have gone to jail on misdemeanor crimes. Look at the Cynthia's Norton case out of Philadelphia. 4 executives, which we hear Steve and Patrick and Joe talking about here, and you yourself, went to jail. Now, small amount of jail time, between, I think, 5 and 10 months. Those were misdemeanor pleas where they didn't even admit to having done anything wrong, under a doctrine called the Responsible Corporate Officer Doctrine. The prosecutors have powerful tools to put people in jail. I can't answer why they're. Look, I don't want to see anybody go to jail.
What happened?
But there are tools that prosecutors have if they want to do what
They happened to have a judge who didn't want to buy the recommendation of the prosecutor. What happened was, and that's one of the biggest problems we have, the judiciary is not taking on these drug companies. The fact, as Joe Trautwein points out, they don't necessarily have to bar them from being able to sell their products. They can limit that penalty. Judges can control this. The real problem here is there's a lot of money involved, and it's a relatively new field. In other words, it kind of got kicked off in around the early 2000s. The first cases were filed. In fact, it took me, I filed the Risperdal key tam against Johnson & Johnson & Janssen in the year 2004.
Right.
We just settled it in 2013.
Right.
It takes years, and it takes quite a bit of work.
Well, going to that issue, Steve, okay, I see Zane Meminger, he won Lawyer of the Year award, $2.2 billion prosecution of Johnson & Johnson. And yet, when I read through the entire article, I hear that there's only a misdemeanor. And again, this is only me, former prosecutor myself. I'm thinking, as a prosecutor, it's great you got the money, but as a prosecutor, what do we do as prosecutors? We put people in jail is what we do. Nobody went to jail again. You had a CEO for Johnson & Johnson, there he is up on the screen, who actually was the marketing director
during the time that the worst offenses were committed. Lies, fraud, cheating, people died. They pled guilty to a misdemeanor on the elderly, and elderly were actually dying as a result of the use of Risperdal and the drugs. Unbelievably.
When I have to deal with a set of facts for a client, you have to deal with facts. And it's one thing to say this parade of horribles that Steve is throwing out and connecting the dot to the CEO of the company. There has to be intent to defraud. We're talking mainly about False Claims Act or off-label marketing, and you have to prove that person intended to defraud beyond a reasonable doubt. We're talking about the top people in the company. It's not enough to say there are lies and there's deceit and this and that. You have to prove your case.
Obviously you have to, but if you've already proven your case, well, you've gotten the corporation to settle. Then
with no admission of liability.
Well, isn't that the get out of jail free card? Because when you were admitting to $2.2 billion worth of wrong and saying, I don't know how it happened. Joe Trautwein, let me throw this one to you because this intrigues me. Take a look at what we've got up on the screen here. This is a picture of Montgomery Ward Chairman Sewell Avery back in the 1940s. They had supplied the Allies with everything from tractors to auto parts. Roosevelt was upset with him because Avery refused to comply with the terms of 3 different collective bargaining agreements. And here he's got his National Guard carrying Sewell off to jail. Now, I'm not saying we go that far, but haven't we gone almost to the other end of the spectrum that no matter how bad these cases are, no one's going to have to really suffer the penalties personally?
I don't think so. I don't think you're going to see that in the future. I think liability is going to be increasing in the future now that you have these corporate integrity agreements. But let me just tell you this. So you have plenty of different aspects, right? You want to put somebody in jail for the crimes that they committed. You want to collect the money that the government's been defrauded. You want to change the culture. Sometimes getting all 3 of those in one package is extremely difficult. You can imagine the defense that these companies put up just returning the money that they have to return. You can imagine the defense that they put up just trying to change the culture. When you're talking about putting people in jail, you know the defense is going to become even greater. So the time and the effort to try and get all 3 is extremely difficult. So I imagine there is some type of compromise where the government has to think and say, okay, what are we going to get out of this case? Are we going to get all 3, or are we going to risk getting nothing?
Right.
So sometimes those tough choices are made.
Right, and if you're going to return over $2 billion, or in the case of Bank of America, $17 billion to the taxpayers, people like Mr. Burns should be pretty happy with that. The American public might not be, but Pat Burns, Taxpayers Against Fraud, might be. When we come back, not every company does it wrong, even when they have done wrong, but the story of Shire and Adderall is an intriguing one. What to do when the feds come knocking. We'll be back in a minute.
This week's American Law Journal has been made possible in part by Law Catalyst, legal media and marketing for lawyers. Go to lawcatalyst.com. Leventhal, Sutton, and Gornstein. We have your Social Security disability case covered. Polanski and Polanski, former U.S. government counsel, representing those seeking Social Security disability benefits. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.
Holding big corporations accountable for bad behavior. That's our topic tonight. Whistleblowers and False Claim Act cases have ballooned over the past few years in both numbers and in actual settlement figures. 4 great guests with me this evening. Joe Poluka returns to our program with Blank Rome, a top 200 law firm. Joe is a corporate defense counsel and a former assistant U.S. attorney. That's a federal prosecutor. Joe Trautwein is also the same kind of prosecutor, assistant U.S. attorney in a former life. He was with the Eastern District of Pennsylvania, now a private practice civil trial attorney who takes on cases that often represent the plaintiff. Steve Scheller, a familiar face over the years here on ALJ, representing individuals who have been harmed by dangerous drugs and Dangerous Products. His upcoming book, A Nation Betrayed, will look at corporate greed. And Ed Silverman returns once again. He's with Pharmalot and now with the Wall Street Journal. Folks, let's take a look at this Shire case that just came down. Shire is the manufacturer of Adderall. Many of you have kids who have ADHD issues, may have given your child Vyvanse or Adderall. Both are Shire products. And what they said, Steve, is that maybe Shire handled this correctly, that they didn't fight the DOJ when they came swooping in, that they cooperated. And so instead of seeing a $1 billion or a $500 million settlement, which is not unheard of, the feds only hit them up for $60 million. What went on there?
Shire did fully cooperate. They came in and did a mea culpa, so the U.S. Attorney explained to us. The other problem is the drug itself, Vyvanse and Adderall, are approved by the FDA, are being used on label. There was very little evidence of kickbacks and fraud. Yeah, they were saying your kid could get an A in math, or they were saying that Vyvanse didn't create as much dependency as other drugs, amphetamines. But there was a struggle going on as to how serious the misconduct was. And we had a lot of trouble getting the U.S. Attorney finally to do something about it, because I thought the misconduct was substantial.
In terms of the cooperation point, again, that's even a continuum. You know, a DOJ subpoena hits my desk. The first thing it is, yeah, we're going to be fully cooperative. That doesn't mean we're going to admit that we did anything wrong. We're going to get you the documents you need. We'll come in, we'll answer your questions. But if we think we have a defense and we think it's a difficult case for the government to prove, we're going to do that. On the other continuum side of cooperation, you see different outside counsel for corporations. Sometimes for credibility's sake, they'll hire someone other than their normal outside counsel. You talk to some of those counsel, they feel like they've been deputized, that they're now government agencies working to ferret out. So again, it really depends on the case. The $60 million, it sounds low. To me, $60 million is still a lot of money. That's a lot of money.
Ed Silverman, does sound like Shire handled this one correctly. Is that the word through Pharmalot as well? I'm sure you covered this matter. What's your take on it?
Yes, I would largely agree with that. It would appear that the government, on one hand, talked tough. When they announced the settlement, they made a point of saying the company, Shire, had promoted the use of its drugs for taking care of such things as sexually transmitted diseases, criminal behavior, traffic accidents. It sounds pretty good. Who would want such a pill, right? So they tout that. It sounds outrageous, and it is. On the other hand, relatively speaking, I agree, $60 million is real money, but it pales in comparison to some of the other settlements we've seen. So the DOJ sort of set itself up for some second guessing as if it's a tiger with no teeth.
Joe Trautwein, you have to give a lot of credit to defense counsel. I mean, they're doing things like making sure that they can tamp down on the dollars that we're talking about. Maybe they can convince the Department of Justice to drop the case, because after all, you may make $10 or $15 million, but don't you have bigger fish to fry? I mean, don't you have to give kudos to really sharp defense counsel who go in and represent the best interests of their client?
I think that's correct. In this case, it was a little different. The allegations that Ed has mentioned are just allegations. When you look at the actual settlement itself and you look at the covered conduct, you're talking about a superiority claim. Basically, the company saying our drug is superior than another drug, right? And to prove that that's false is extremely difficult, because you're going to have expert versus expert. And when you look at what happened in this case, that was the struggle. Obviously the company did cooperate from what we heard, but they didn't give up on their defense. It says, look, this is not a false claim. We're claiming that our drug is superior. You may disagree, but these are the experts that we have that say it is. So from that standpoint, it makes it a very difficult case, especially when you consider the dollars involved.
Ed Silverman, interesting thing about this kind of case, and again, we have both Joe Trautwein and Joe Poluka with us tonight. I would think in any kind of a whistleblower case, if you're the whistleblower, you've got your plaintiff's attorney, because again, they're the ones who work with the DOJ. You've got defense counsel working with the corporation, and yet no one would go to the table with one of these kinds of cases without a former assistant U.S. attorney on their side. You'd be nuts not to, correct?
Well, sure. If you want to get something done, go to people with experience.
Yeah, but beyond that, let me ask you a question. Is it more than just experience? Is it about access? Because let's face it, attorneys talk to the U.S. attorneys while they're investigating a case. I mean, Steve Scheller, got the U.S. attorneys in the Eastern District of Pennsylvania to look at Zyprexa and looked at Risperdal. Lots of cases end up on the DOJ's desk at the end of the day. Certain ones get picked up. Doesn't access count for something? Can you comment on this?
It's like anything else in life. It helps to know people who know people who know people. And this is no different. And it's a small world when all is said and done. You have just so many attorneys who are specializing in this. And you have, I wouldn't say it's a revolving door, but you have people who go back and forth depending upon their stature. And they know the rules, they know the game, and they know whose buttons to push and who to go to. So
I agree with the point made by Ed about access. You know the process. You know how the system works. But I think, and it gets you in the door, I agree with that, but I think the key is credibility. Are you credible? Whichever side you're on, when you go in, are you credible? And I've been beating this drum all night, and I think credibility really depends on the facts.
That's a good
Have you
point.
marshaled the facts to put your client, whether it's the whistleblower or the corporation, in the best
You
light?
have to have counsel present the case, we used to say, on a silver platter to the U.S. attorney, because the work is really done by the plaintiff's lawyers like me. And there aren't many of us that can do that kind of work. And we now say we present it on a platinum platter. Because we do almost everything. And I know the Department of Justice takes the credit, but let's make it clear. We do most of the work. And a lot of this wouldn't happen if it wasn't for the effort that we made to get our whistleblower a successful recovery. The problem that we face here is we need more than a successful recovery now, because we don't do it just for that. We do it because it's the right thing and it's necessary. And that's something that is really troubling me, and it's why this book is going to come out called Our Nation Betrayed. Because when you have the U.S. Supreme Court, 5 of those guys, saying that corporations are like people, they're like me, and yet you have judges letting them get away with these kinds of things, and you wouldn't let a simple person like me get away with it, would you? But we let the corporations get away with it, and the high-up guys up there with their millions of dollars and their $50, $60 million golden parachutes. This has got to stop.
It's interesting, Joe Trautwein, that we talked a while ago about whistleblowers, and yes, they are remunerated. They do get a cut, if you will. If they are the ones that are blowing the whistle on the corporation performing the bad act, let's say illegal off-label marketing, they do get a percentage. And yet, I've rarely heard of an assistant U.S. attorney say, they came to me because of the money. Now, just tell it straight up. Are they there because of the money? Somewhat, a lot, not at all? Or are they there because they really want to see justice done?
Chris, in my experience, the whistleblowers that have come to us are not there for the money, right? You've seen some of these outrageous settlements, some people call them, where whistleblowers share $100 million. But when those cases started out, no one even dreamed that that would be the recovery. These whistleblowers come because they want this action to stop. These whistleblowers come because they uncovered something that's hurting the public, hurting children, hurting the elderly, and they want it to stop. No one can predict with any accuracy how much money they're going to get at the end of these cases. If they're in it for just the money, a lot of them are going to wind up broke, because not a high percentage of these cases settle. And it's my experience that most of these whistleblowers come because they want this conduct to stop and they want the wrong to be righted.
I want to thank my guests for joining me tonight. Joe Poluka, great guest tonight, our corporate defense counsel on the panel from Blank Rome, former assistant U.S. attorney in Pennsylvania. Joe Trautwein with us for the very first time, a law firm that bears his name in Blue Bell, Pennsylvania, a former assistant U.S. attorney, now in private civil practice. Steve Scheller, plaintiff's attorney since 1977, and Ed Silverman with Pharmalot, now with the Wall Street Journal. Thanks so much for joining us, folks. For all of us here at the American Law Journal, thanks for joining us. Until next week, case closed.